Hey, April.
Yes.
It appears Miss Smith's ability to hear. I don't know if she can hear.
That would be on her end.
Okay, all right.
We're gonna take Mr. Harvey now.
Judge, this is the state of Georgia versus Andrew Smith. I believe I emailed you a document from Dr. Norman last week, and I'll resend it for you. Indictment number 19 SC 173779. I believe that
You gonna send it to me
well,
now?
Ms. Winfrey is present and the victim is present. I'm not sure if she can hear us. Can you hear us, Ms. Julia?
I can.
Okay. All right. Thank you. Go ahead, Ms. Winfrey.
I remember the day.
It's my motion, Judge.
Good morning, Mr. Harvey.
Good morning, Judge. Can you hear me okay?
Yes, sir.
Ms. Winfrey, can you hear me okay?
Yes, good morning.
Good morning. Judge, this is the second appearance of this case. We had a bond hearing originally. I don't know whether you want me to refresh you.
No, I remember the facts. It involved a teenage
Okay.
daughter. Now,
Yes.
the parties divorced, so they separated, Miss Julia.
We are divorced.
You're divorced. All right, go ahead.
And Judge, you had indicated that you wanted Dr. Norman to evaluate Mr. Smith. And pending the results of that evaluation, we would revisit the Mr. Smith's motion for bond. So we're here in that capacity. I did provide Ms. Winfrey with a copy of that evaluation. That evaluation is indeed a current evaluation. It says nothing with regard to as it relates to the time of the event. It relates solely to now. Dr. Norman's conclusion at page 8 on the report says, in his opinion, with a reasonable degree of medical certainty, Mr. Smith does not pose a substantial risk of harm to others or himself based upon his extensive evaluation. He outlines the factors, both pro and con, on page 8 and comes to that conclusion. Once again, just to reiterate a bit, if released, if the court grants a bond, Mr. Smith would live on a 3-acre farm in Woodstock that's owned by his parents. He would live in a house on that property and finish renovating that house. His sister lives on that property. His sister owns a natural food grocery store and production kitchen in Woodstock. If you let him off the premises, he would be able to work at that location. He's got no prior felony convictions. He would abide by any reasonable conditions, clearly a stay away, clearly an ankle monitor, clearly a curfew. I have no objection to required therapy, which is in fact recommended by Dr. Norman. That would include a 12-step program. I don't know whether they're meeting other than by video now. Any kind of therapeutic intervention that the court would require. We have been in contact with several locations in order to be ready if the court needs for or the court requires for any therapeutic intervention. There are intervention programs in Canton, Georgia. One is called Choice, one is called Ascension. Dr. Norman, excuse me for stepping off the out of the camera range. Dr. Norman recommended dialectical behavior therapy and recommended a institution called DBT South, which is on Peachtree, or there are a couple of locations, but that's the therapy that he recommended, dialectical behavior therapy.
Is that an outpatient therapy?
Yes.
Does Dr. Norman recommend that he continue treatment with him?
Well, no. He recommends therapeutic intervention by others. And like I said, we've reached out to a place in Canton, which is close to where the Woodstock location would be, two places in Canton, and two places for professional psychiatric dialectical behavior therapy. That's what he recommends. Now, I mean, he is a psychiatrist, a forensic psychiatrist. If the court says to me, I want him to be under the auspices of Dr. Norman, if I grant him a bond, then I will be happy to arrange it with Dr. Norman at whatever intervals he thinks is appropriate and under whatever conditions the court would allow.
Miss Julia, I don't want to call you by your first name. Do you go by Miss Smith? What do you go by?
Either's fine. You can say Miss Smith or Julia.
Okay. How long were y'all married?
7 years.
And how many children do y'all have?
1.
And that is a young lady?
Yes, she's 7 years old.
Okay. And you have a teenage daughter by another man?
Yes, I have 2 other teenage daughters from a previous marriage.
Okay. And one of the daughters is at issue in this case. Is that correct?
Yes, we were all there at the house at the incident as well.
All 3 daughters.
Yes, we were all there and myself.
What, this seems like an aberration of his conduct if he doesn't have any felony convictions.
I'm sorry, Your Honor, if I may give the court a little bit more information on the Dr. Norman's report that may not have been highlighted, that might be helpful and instructive. Is that okay?
Sure.
Yeah. So while on page 8, Mr. Harvey mentions what Dr. Norman's conclusions were, just up further on page 8, he also states that there is evidence both for and against Mr. Smith posing a risk of harm to others in the future. And I highlight that because there are at least three separate incidents before this that were violent in nature that may not have gone to, let's say, fruition in a judicial system.
And I'll tell you what, I'm going to object to any prior incidents. We're not here to determine the facts of the case. We're not here to determine anything else. If you want to give me some notice about that, I'd be glad to hear that. But I am objecting to that.
All right, listen.
I think it's
what I want to know is Dr. Norman's final conclusion was that he would be okay based on his evaluation of this defendant granting bond.
Well, Dr. Norman actually states that for Mr. Smith has allegedly had a past violent episode. However, there is no evidence of a past history of significant violent behavior prior to October 2019. That was how he came to his conclusion, but that he's not dealing with a full deck of cards. He does not have all of the information. There's a violation of a TPO because there was an allegation with this particular victim, Ms. Smith, where she had to go get a TPO from an incident in May of 2019. This is prior to the October incident.
That's part of this case. That's part of this case.
Exactly.
So let's not litigate the case.
All right. I want to hear from Ms. Smith.
This
Ms.
case.
Smith.
Yes, thank you. I would love to read my statement. He had 2 zip ties around my daughter and duct tape on her mouth. Why would my daughter feel?
And I'm sorry, Ms. Smith, I apologize for interrupting.
I was told that I could read a statement.
Everybody just I understand. I want to hear from her. Go ahead. Go ahead, Ms. Smith.
He had 2 zip ties around. Why would my daughter feel safe if he is released? And who were there and witnessed the attack feel safe? Why would I feel safe? I am now a single mother. Kate of John Christopher. He lived in Cobb County. He was arrested in charges that sound very similar to my ex-husband's. My ex has assaulted me several times. He has said horrible, vile things about me and my family on social media. My ex did these things to me before the horrible attack he committed on my then 16-year-old daughter in October.
Ms. Woods, is there any way that Mr. Harvey and Ms. Winfrey and I can talk on a separate room?
Yes, Judge, I can set that up for you.
Please do that for us.
Okay, now you should get an alert. Who did you want, Judge, again? You want Miss
Mr.
Winfrey?
Harvey and Miss Winfrey in the court. And Miss Harvey, Mr. Harvey, Miss Winfrey in
Yes.
the court.
Okay, I'm trying to find you, Judge. Hold on. Okay.
He's right there in the courtroom, in case
Okay.
you're lost.
All right. Did you get an alert for,
Is that called share screen?
no. Hold on for a second.